on Judiciary, Civil, and Criminal Jurisprudence will come to order. We do not yet have a quorum, so we're going to start off as a subcommittee. First up, Senator Trent on Senate Bill 1509. Senator, whenever you're ready.
Thank you, Mr. Chairman. For the record, Curtis Trent representing Senate District 20. This is Senate Bill 1509. The goal of this legislation is to reform class action lawsuits, make the process fairer and simpler. The way we do that is by mirroring federal law in the majority of other states. And specifically, a few of the highlight changes that the bill would make. So like if you had an order that was certifying class action, that order should define the class, the claims, and the issue. Notices required to be in clear, easily understood language. It allows for dismissal or compromise with the approval of the court and sets forth criteria for the court to use when appointing counsel and when awarding attorney's fees. Basically, the certification process is backwards right now from what federal law does, and we want to put that in the same order. It seems like the federal law has produced fair and balanced outcomes, and we want that for the state of Missouri as well. I'll be happy to answer any questions.
Any questions for the bill sponsor? Seeing none. Can I get a show of hands how many witnesses we have here in support of the legislation? Witnesses in support. Okay, how many witnesses in opposition? All right, so what we're going to do is first witness on each side can have 5 minutes, subsequent witnesses 2 minutes apiece. We've got 2 other bills here after this, and we've only been allotted an hour today for our hearing time. We're also going to have an executive session, so brevity is appreciated by the committee. Mr. Aubuchon.
If I could, Mr. Chairman, cede my 2 minutes or 5 minute time to another individual, that would be right after me, but I'll take 2. Rich Aubuchon on behalf of the Missouri Civil Justice Reform Coalition. There's been decades of history in regard to the federal rule in this regard. Missouri is upside down in this rule. We, instead of certifying the class, we decertify the class, so it's all backwards. And we're hoping that based upon the federal rule, which obviously has been in place in Missouri for decades, that we've seen that their jurisprudence has developed here, that we would like to see a certification process, which, based upon some of the advice from others in a pocket guide for litigation, which I just found last week in this regard, up to 40% of all the cases that are filed in federal courts, based upon the federal courts' research in this, does not certify the class, up to 40%, sometimes 20% given the year. So what I guess I'm getting at here is that if our system is so out of whack with certifying the class rather than decertifying the class, we ought to use the Fed system, make a uniform result. Happy to have any questions.
Questions for Rich? Seeing none, thank you for your testimony. Witnesses in opposition. Witnesses in opposition.
Afternoon, Senator. Thanks so much for letting me testify. My name is Mike Campbell. I'm testifying on behalf of the Missouri Association of Trial Attorneys in opposition to the bill. We actually think that the current formula and the rule in the state of Missouri is working just fine, and it's fair and it's balanced. Some of the changes I just want to highlight specifically that would create basically judicial inefficiency and would actually unnecessarily burden our circuit courts and our appellate courts. In the bill itself, Rule 5208, there's an amendment to subpart F, and what it states is that appellate court shall, it removes may, permit an order denying or approving class certification. What that does, and what I heard previously, was that this was going to try to streamline the state rule to be compatible or comparable to that of the federal rule, or the federal rule, whenever they consider this specific issue, they take into consideration what's called careful calibration, which would basically, if we just mandated that the appellate court took every single appeal, it would clog the entire system up and not give discretion whatsoever, or give them the opportunity to carefully calibrate whether or not this was an appeal that needed to be taken or not. And so it would clog an already burdened court system and create unnecessary burden and expense on the parties. Also, 5208, I believe it's H41, which is regarding the burden of proof, and that requires the party to seek class certification to prove every requirement of the rule by a preponderance of the evidence. And the court shall not err in favor of certification. That's what changes the rule. It shall not err in certification, but instead apply a rigorous analysis. The difference between, as I'm sure the senator or the chair is aware, the difference between the federal rules and laws as it relates to pleading requirements and state pleading requirements is that Missouri is a fact pleading state, which means that we have to be extremely detailed in our factual analysis of the claims that we are making, whereas in the federal rule and the federal system, it's a notice requirement, and a large part of the federal, when you file a lawsuit in the federal court system, a large part of figuring out whether or not the plaintiff can meet his or her burden is borne out in discovery. What this change does is it basically grafts a requirement that's in a notice pleading system onto a fact pleading system. So the circuit courts are already doing a rigorous analysis of the pleadings as it is. So this is unnecessary, redundant, and it creates an unnecessary burden on our circuit courts. And then also C, the certification order. It removes the court's ability to make a conditional decision about whether a class can be certified. I mean, this basically what it says is that, let me pull out the specific language of the rule here. There's this, it allows for, so it would allow for a decision on the merits to be made. But before a judgment is entered, or before a judgment is final, a number of the class claimants can either jump out or jump into the proceedings on the plaintiff's side, whereas right now they have to make that decision prior to the decision being made on the merits by the court. And what this change does is it says is that, hey, a decision on the merits can be made, but you can allow for all these procedural games to take place before the judgment is final. Again, what that does is it creates a lot of gamesmanship on both sides, both the plaintiff and the defendant, and it would also, again, unnecessarily burden already overburdened circuit court system that we have in the state of Missouri. So for those reasons, we oppose the bill.
Any questions for Mr. Campbell? Okay. Seeing none, thank you for your testimony.
Thank you, Senator.
Thank you. Since we do have a quorum present, I am going to make a motion to go into executive session. Do I have a second? It's been moved and seconded. All those in favor signify by saying aye. Aye. Those contrary, no. The aye has it. We are in executive session. Oh, yeah. Madam Secretary, would you please call the roll?
Senator Lukemeyer.
Here.
Schroer. Coleman. May. Roberts. Thompson Rader. Trent.
Here.
We do have a quorum. I would now make a motion that we go into executive session. Do I have a second?
Second.
It's been moved and seconded. All those in favor signify by saying aye. Aye. Those contrary, no. The ayes have it. We are in executive session. I would now make a motion to bring before the committee for consideration House Committee substitute for House Bill 2700. Do I have a second?
Second.
It's been moved and seconded. All those in favor signify by saying aye. Aye. Those contrary, no. The ayes have it. Bill's before the committee. We do have a Senate committee substitute on this bill. It was circulated last week to the committee. We removed a handful of provisions that were presented on as a part of House Bill 2700. Most of them appear to be added as floor amendments and did not go through the full vetting process in the House. Similarly, did not go through as separate bills in Senate committee. That was the main reason for removing those provisions. We also made some changes. As the committee will recall, we previously voted out of here Senate Bill 754, which was perfected and third read by the Senate and sitting over in the House right now. And so to avoid any inconsistencies between a bill over here and a bill over in the House, we have modified the provisions that were in the perfected 754 to match what we're getting ready to vote out of committee. And that's basically the sum and substance of the committee or the Senate committee substitute for House Bill 2700. Is there any discussion on the Senate committee substitute?
Very briefly.
Yes, Senator Roberts.
I was just going to say that I like the overall theme of the bill. There's some a tweak we might need to make, so I'll vote no in committee, but I intend to support it on the floor.
Okay, great. There was actually an oversight, and I will take the blame for this. We had inadvertently removed a handful of provisions that are technical fixes to raise the age that were actually in 2700 when we heard it. There was no opposition to those provisions. So I'm going to make an oral motion to amend the committee substitute before we adopt it to add those sections back in. But again, these would have been sections that were all previously in 2700, which we had the hearing on, have been through the House Judiciary Committee, and again, are just technical fixes to raise the age that were, through inadvertence, taken out of the Senate committee substitute. So with that, I would make a motion that we add to, I offer an amendment to add to House Committee Substitute for House Bill 2700 the following sections: 211.033, 211.072, 219.021, and 221.044. Is there any discussion on that? Okay, hearing none, I would now make a motion to adopt the amendment. Is there a second? It's been moved and seconded. All those in favor signify by saying aye. Aye. Those contrary, no. The ayes have it. You've adopted the amendment. I would now make a motion to vote to adopt Senate committee substitute for House committee substitute for House Bill 2700 and to roll the amendment that we just adopted into a new committee sub. Do I have a second? It's been moved and seconded. Any further discussion? Seeing none, all those in favor signify by saying aye. Aye. Those contrary, no. The ayes have it. You've adopted the Senate committee substitute. I would now make a motion that we vote do pass Senate committee substitute for House committee substitute for House Bill 2700. Do I have a second? It's been moved and seconded. Any further discussion? Seeing none, Madam Secretary, please call the roll.
Senators Lukemeyer,
Aye.
Schroer, Coleman, May, Roberts, Thompson Rader, Trent.
By your vote of 3-1, you have voted do pass Senate committee substitute for House committee substitute for House Bill 2700. I would now make a motion that we bring before the committee House committee substitute for House Bill 1886 and 2064. Do I have a second? It's been moved and seconded. All those in favor signify by saying aye. Aye. Those the contrary, no. The ayes have it. This is the civil proceedings bill that we heard last time from Representatives Veit and Copeland. We have rolled the two bill numbers together in the proposed Senate committee substitute. We scaled back the bill to remove a handful of provisions that were not vetted previously by the Senate or raised objections from members of the committee. And so the hope here was to kind of have a consensus civil omnibus judiciary bill. It matches the provisions that we previously voted out from Senator Trent's Senate committee sub for Senate Bill 897. So the provisions in the bill should be familiar to members of the committee. Is there any discussion before I make a motion to adopt the Senate committee substitute? Seeing none, I would now make a motion that we adopt Senate committee substitute for House committee substitute for House Bills 1886 and 2064. Do you have a second? It's been moved and seconded. All those in favor signify by saying aye. Those contrary, no. You guys have it. You've adopted Senate committee substitute for House committee substitute for House Bills 2064 and 1886. I would now make a motion that we do pass Senate committee substitute for House committee substitute for House Bills 2064 and 1886. Do you have a second? It's been moved and seconded. Any further discussion? Seeing none, Madam Secretary, please call the roll.
Senators Lukemeyer,
Aye.
Schroer, Coleman, May, Roberts, Thompson Rader, Trent.
By your vote of 5-0, 4-0, you have voted do pass Senate Committee Substitute for House Committee Substitute for House Bills 2064 and 1886. We will leave the board open for members of the committee who get here late who would like to vote. But I would now make a motion that we exit executive session. Do I have a second? It's been moved and seconded. We are out of executive session. We are back on committee testimony in support of Senate Bill 1509. Next witness in support.
Good afternoon, Matt Price from Diamond Pet Foods in support of 1509. The problem with the procedure as currently constituted is it forces the onus on the defense to convince the court to undo something versus the burden being on the plaintiff to do something. This aspect of procedure was amended by the federal courts 20 years ago. Missouri is now out of step. Companies are caught back-footed by this outdated rule, which encourages non-meritorious shakedown lawsuits and class actions. In Diamond Pet Foods' case, we are 4 years into litigation, millions of dollars of outside counsel costs, where the motion to decertify is still pending before the court. So we've gone into discovery, we've gone into all sorts of other motions before the motion to decertify has even been heard. This would bankrupt smaller companies. Corporations often settle these cases, even those that would have had little chance of certification had the playing field been leveled from the outset due to the cost of defense, the risk of nuclear jury verdict, and brand damage. The bill we are supporting simply seeks parity with the federal rules and seeks equity with other states that have rightly identified that the burden belongs to the plaintiff bringing such a serious action to show some justification for doing so by convincing the court that the factors inherent in a class action, numerosity, typicality, commonality, and preponderance, exist. Many states have already enacted this type of reform, most states, in fact. And again, the federal rule is 20 years old. To be crystal clear, we do not consider this a red state or a blue state type of issue. This is a pro-business and a jobs issue. This is a rule of law issue where the score should be 0-0 at tip-off, and where the moving party, as in all cases, bears certain burdens of proof. Here's a sampling of states that have already enacted similar rules to mirror Rule 23, which we believe demonstrate that this is not a red state or a blue state issue. California has adopted these rules. Connecticut, Minnesota, New Jersey, Wisconsin, and Washington, D.C. There are more defense-friendly rules that we could propose, which states like Texas have, which is why we sincerely believe this is a middle-of-the-road, common-sense approach. These types of more defense-friendly version could include things such as statutory limits, which would be a minimum recovery for every class member, or class members' recovery, staying discovery after a motion to dismiss is filed. We're not seeking any of that. We simply want consistency with the federal rules, and we want parity with what other states have done so that Missouri businesses enter class action litigation with the score 0-0 at tip-off, where the requirement to demonstrate the merits of the class, preponderance, commonality, typicality, and numerosity, are rightly on the moving party. I anticipate you'll hear arguments from the plaintiff's bar, and perhaps even from colleagues on the right, that this bill will somehow infringe on a plaintiff's right or a citizen's right to trial. And we submit that this argument is a red herring. First, we are talking about weeding out non-meritorious class actions, not the meritorious ones. If a plaintiff can simply demonstrate to the court the minimum necessary factors inherent in a class, numerosity, typicality, commonality, and preponderance, the case moves forward. If the case is certified, these cases likely go to settlement. And I anticipate any plaintiff's lawyer getting in front of this panel today with a class action practice also practices in federal court where these rules are what we're proposing today. These rules are not going to be new to them, and these plaintiffs' lawyers know that getting a class certified in federal court is not an insurmountable hurdle. They're simply a necessary gate check to weed out non-meritorious class actions in federal court. But by having a two-tiered system in Missouri, one for federal actions, one for state class actions, we've created a mechanism where the meritorious cases end up in federal court, the non-meritorious or nuisance class actions end up in state court where the rules are currently rigged in the plaintiff's favor. There are other states, such as Texas, that go much further than what we're seeking here, and there are many, many successful class action plaintiffs' attorneys in Texas, some of whom have national practices and do so well that they're able to make sizable contributions to certain candidates in other states, including Missouri. Finally, we submit this is not a big business bill. Most businesses in Missouri are small businesses. In 2021, 96.4% of businesses in Missouri were small businesses with 50 or less workers. The average size of a small business in Missouri is 14 employees. And small businesses bear 81% of all business tort liability cases. They lack the resources to fight and to defend meritless lawsuits. And when faced with the prospect of extensive or expensive litigation and distraction from running the business, they settle. At one time, Diamond Pet Foods was such a small company. Had the class action that we're facing today, where we are millions of dollars into outside counsel fees before we've even been heard on our motion to decertify, had this case caught us in our infancy, we might not be the company we are today. There's also the consumer to consider. According to a nationwide poll, 62% of small businesses make decisions to avoid lawsuits, and 61% of those businesses pass on the price of this to their consumers through products and services. And finally, this is a jobs bill. In 2020, excessive tort litigation, including class action litigation, cost Missouri over 55,000 jobs. In conclusion, this bill, which we consider to be apolitical and a compromise from the start, simply mirroring the federal rules and seeking parity with the federal rules and all the other states that have enacted it, solve a lot of problems at once. It promotes equity with the federal rules in other states. It relieves significant risk to growing Missouri businesses. It prevents significant litigation costs being passed on to consumers, promotes job growth, and protects the rule of law. Thank you for your time and consideration. I'm happy to answer any questions.
Thank you. Any questions for the witness? Senator Thompson-Raider.
Thank you. And I may have missed this, but how many states did you say have already passed this?
Most. Stop counting at around 30.
Okay, got it. Thank you.
And this is substantively identical to the federal rule.
It is, by the word.
Okay.
Yep.
So it's identical.
It is identical, carbon copy.
Great. Any further questions for the witness? Seeing none, thank you for your testimony.
Thank you.
Further witnesses in opposition, I think we only had one. Were there any further witnesses in opposition, though? Seeing none, further witnesses in support.
Mr. Chairman, members of the committee, for the record, Ray McCarty, President of Associated Industries in Missouri. I want to go on record in support of this. Again, if it's good for the federal law, we should be able to do it here in the state as well. And we think that it makes sense if you're saying that there's a class there to be able to prove it. Happy to answer any questions.
Any questions for Mr. McCarty? Seeing none, thank you for your testimony. Further witnesses in support.
Good afternoon, Mr. Chairman, members of the committee. My name is Doug Galloway. I'm here representing Ford Motor Company today. Thank you to the sponsor for introducing this legislation, and to you, Mr. Chairman, for holding the hearing today. We just want to go on record of supporting the legislation, and we think it's common sense that you just mirror the federal law.
Any questions for Mr. Galloway? Seeing none, thank you for your testimony. Further witnesses in support.
Mr. Chair, Michael Henderson for the Missouri Insurance Coalition, in support of this bill for the reasons already stated. Thank you.
Any questions for the Insurance Coalition? Seeing none, thank you for your testimony. Further witnesses in support.
Mr. Chair, members of the committee, Heidi Geis-Buehler-Sutherland here on behalf of the Missouri Chamber of Commerce and Industry. As previous witnesses have noted, it provides parity with the federal law and also makes Missouri more business friendly.
Great. Any questions for the chamber? Seeing none, thank you for your testimony. Further witnesses in support.
Good afternoon, Senators. Marty Miller with Quaker Window Products, and really for the reasons already stated, we're in support of this bill as well. Seems like a common sense effort to bring our state rules more in line with federal and make it clear that a part of the plaintiff's burden in proving up their case is demonstrating that you've got a valid, appropriate class.
Perfect. Any questions for the witness? Seeing none, thank you for your testimony. Further witnesses in support.
Mr. Chair, Brian Waller of Shelter Insurance, just here to vote in support.
Okay. Any questions for Mr. Waller? Seeing none, thank you for your testimony. Further witnesses in support. Seeing none, any witnesses for informational purposes only? Seeing none, that will conclude the hearing on Senate Bill 1509. Next up is House Committee Substitute for House Bill 1777 et al. Representative Perkins, whenever you're ready.
Thank
Thank you, Mr. Chairman. Chad Perkins, that's the 40th District, Pike and Lincoln County. There's a number of provisions within House Bill 1777. I'll quickly go over all of those. The first one of which is expanding good time credits to offenders who participate in certain programs, whether they are educational programs or programs that are helpful in any number of ways. It's a restorative justice program allowing up to 90 days credit per calendar year. I think we all agree that rewarding good behavior is a good policy that the state should have. It also requiring the Department of Corrections to provide state IDs to people who are getting out of prison. The science shows us that if you have those basic documentations, you can get jobs more easily, you can get into education or housing more easily. It's almost a human rights issue to some degree there. It also has an interesting provision increasing the age from 14 to 18 for children related to certain offenses when it comes to reliving the horrors that they've gone through so many times before. It can be quite traumatic to have to relive that, and it's just changing that age from 14 up to 18. It requires county jails to develop a procedure for intake and care of pregnant offenders, including dietary supplements. I think we can all agree that someone who's in jail and they happen to be pregnant, having additional calories a day is certainly, to me, that's a pro-life issue, and I think it's a very good issue. It prohibits the use of restraints for pregnant offenders who are in their third trimester, which also I think speaks very much in that same vein as the last provision. And then finally, it allows convicted individuals who've been convicted of a drug possession to be eligible for SNAP benefits. Really interestingly enough, if you were convicted of a violent offense, whether it is rape, murder, anything of that nature, when you get out of prison, you qualify for your SNAP benefits. The only people who do not are those who've been convicted of a nonviolent drug offense. And it's just putting that in line with crimes that are far beyond what we've already discussed. But with that, I'll take any questions.
Any questions for Representative Perkins? Seeing none.
Thank you.
Witnesses in support of House Bills 1700 et al.
Mr. Chairman, members of the committee, Alex Eaton, testifying today on behalf of Action Now Initiative and Families Against Mandatory Minimum. We would like to go on record in support of House Bill 1777, specifically the provisions that Representative Perkins mentioned, SNAP benefits, the prisoner ID reentry documentation, which there is some updated language that we've worked with on with the Department of Corrections that I've shared with your office. But if this is going to move forward, I think we should just clean that up to make, we worked with them to make sure they're supportive of it. And then the good time credits piece also. Specifically, we would ask that the committee remove the truth in sentencing piece in the bill that was added on the House floor, was not filed, brought up without debate. But typically, or the fiscal note indicates that would be a cost of $27 million to the state. So happy to take any questions, but overall support the bill with the caveat that we take a look at that provision.
Any questions for Alex? Seeing none, thank you for your testimony. Further witnesses in support?
Thank you.
Mr. Chairman, members of the committee, Organ Schlemer on behalf of the American College of OBGYNs, we are in favor of the bill, specifically page 5, line 1, section 277, I think it is, regarding shackling in jails. We passed the law for correctional facilities a few years ago. This now applies that also to jails for safety for mom and baby both.
Any questions for Mr. Schlemeyer? Seeing none, thank you for your testimony. Further witnesses in support?
Good afternoon, Mr. Chair, members of the committee. Sharon Galway-Jones here on behalf of Dream.org, testifying in support of the bill, specifically the good time credit section in 558041. We'd love it if that could get added to one of the bills moving, if this one should not move forward. If this does move forward, the language in 558019 that Alex also mentioned that was amended by Representative Hovis, we'd ask that that be removed. That has not been vetted yet. With that, I'd take any questions if you have them.
Any questions for Ms. Jones? Seeing none, thank you for your testimony. Further witnesses in support?
Thank you, Mr. Chairman, members of the committee. Samuel Lee with Campaign Life Missouri to go on record in support of House Bill 1777 and specifically the provisions dealing with shackling of pregnant and postpartum offenders in local jails, as well as the nutritional support. certainly the shackling provision is entirely consistent with the pro-life movement supported in 2018, which prohibits shackling in almost all circumstances except for extraordinary circumstances in state correctional institutions. We think this should be extended to county jails, and as some of the counties have done. I would point out that not only is it consistent with what we passed in 2018, but the provision which prohibits shackling during that 48-hour postpartum period definitely helps mom and baby to bond. That skin-to-skin contact between a newborn and his or her mother is crucial, and breastfeeding, especially early breastfeeding. And obviously, if she's shackled, she can't breastfeed, or certainly not do it very easily. And that nutritional support is something that is also consistent with your bill, Mr. Chairman, on the correctional center facilities for newborns, which hopefully will go into effect. Well, it's supposed to go into effect next year. So that, and also provisions in Missouri law that allow for breastfeeding in both in private and public, entirely consistent with that, and certainly support those provisions.
And I should have asked the prior witness this because he had made reference to it, that the provisions that are in the bill are identical to what we previously passed for restrictions on shackling of women when they're in the custody of the Department of Corrections?
Correct.
Okay.
Absolutely. Yeah.
And
I
so
double-checked that, except for sheriff versus versus state Department of Corrections. Other than that, it's identical.
So this is just extending those protections that are already in place for DOC to county jails?
Absolutely.
Okay,
Correct.
got it.
Yes.
Great. Seeing that there could possibly be no further questions for you, thank you for your testimony.
Thank you, Mr. Chairman.
Further witnesses in support?
My name is Liza Weiss. I'm the Executive Director of Missouri Appleseed. Thank you, Chairman Lukemeyer, for allowing testimony on this bill. We're here to support the bill, and just I wanted to follow up on what Mr. Lee was saying. Not only is the language similar to are the same as the language that Representative Gene Evans passed that applies to the state facilities, but this is very similar to the language that President Trump signed in the First Step Act, and that the American Conservative Union supported creating model language for ALEC, except this language is actually watered down. It's less restrictive. The First Step Act and the model ALEC legislation applies to women throughout their pregnancy and 30 days postpartum, and we're just asking for the language to apply in the last third trimester of the pregnancy and 48 hours postpartum. And just again to follow up with what Mr. Lee said, this is, those 48 hours are very crucial, and of everything we know about. Not only are they beneficial for the baby, but also for postpartum depression. And just again, also thank you again for the passing legislation related to the prison nursery. We're so excited, and I think they might even be on schedule to open early. So we're excited. So thanks for having me.
Thank you for your testimony. Further witnesses in support?
Good afternoon, Senator. I'm Christine Woody. I'm with Empower Missouri. I'm specifically speaking about the revision regarding the lifetime ban on SNAP for those who have a drug-related felony on their record. So we've been working on this piece of legislation, or this issue, for about 16 years. I've been with Empower Missouri since 2006. 2014, then State Representative Paul Wieland and State Senator Kiki Curls worked on a bill that got passed and signed into law that addressed this. The whole legislative process, there's a lot of compromise and modifications that happen. During that time in 2014, the bill was modified. It was not a complete opt-out ban, but I still thought that was a success. A few years ago, an attorney at Legal Services of Eastern Missouri, who we work with, who works very closely with individuals who have criminal records, informed me that she has rarely, if at all, ever been able to get a client of hers on the SNAP program, just because the way that the current law is written, it's very complicated and very difficult to navigate, and it's really a challenge. So that really is, I think, a key point of red tape and bureaucracy that just doesn't help the individuals that we wanted to help. It's cumbersome for the SNAP applicants and for the DSS caseworkers who have to go through the process of going through the applications. The way that this bill works is this provision was created on the federal level, but it allows states to opt out of it if they wanted to. Currently, we are only one of a few states that have not done that. States like Arkansas and Mississippi and Alabama and many other states have completely opted out of this provision that only affects those who have a drug-related felony. So I really appreciate you hearing this bill and hopefully moving this forward so we can maybe completely get this done this session. And I really appreciate your time.
Thank you.
Thank you.
Okay, so just so that I understand,
Yeah.
and Representative Perkins mentioned this earlier.
Yes.
So the only crimes currently that prevent people from being eligible for SNAP benefits are drug-related offenses.
Yes.
So
And-
there are no other offenses.
No, so this was a federal provision that was created in '96 when all those welfare reform bills and war on drugs crime bills that were moving through the federal level. And SNAP is all regulated and administered on the federal level and then just run through the states, right? So in '96, when they were doing a lot of those reforms, they put a provision in there that said if you have a drug-related felony, you have a lifetime ban against accessing the SNAP program. But when they passed that law, they also said that states can decide if they want to follow it or opt out of it. And so since '96, multiple states have opted out of it.
Okay. And the current status of the law in Missouri
Yes.
is that we don't say that you can't get SNAP benefits if you're a drug offender. We just say that you have to jump through certain hoops to get it.
Yes.
Drug testing, a handful of other things that are in the statute right
Yeah.
now. And
Yes.
so if we adopted this provision,
Yep.
would there be any type of oversight then from the state, or if you're a drug offender, would you automatically receive SNAP benefits?
So currently what happens is there's all these forms and applications you have to fill out. So if you have a drug-related felony, I actually have the form. It's like 2 pages. It's like check yes or no. Have you gone through drug treatment? Yes or no. Has it been approved by the Division of Drug and Alcohol Abuse, which actually is not even a division anymore. They've renamed it and not updated the forms. Do you have a urinalysis test that you have to pay for yourself? So yes, they have all these like check boxes that you have to mark, and then you submit that, and the department caseworker has to then go and check CaseNet and do all of these like provisions to have that. None of those questions will be on the application. So right now, you don't have to say, I have a felony. The only question is, do you have a drug-related felony? Yes or no? Check, 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 check. Right now, if this passes and we completely opt out of it, that sheet wouldn't even be a thing. It would not be a question. It would not be something that would have to be checked, double-checked, and asked about.
Okay, so in other words, if somebody was convicted of a drug felony, they are released from incarceration,
Mhm.
or more likely, if it's a nonviolent offense, they're placed on probation.
Yes.
Then they would no longer have to fill out the form, no longer have to go through drug background checks to remain eligible for SNAP benefits.
Yes. Yes. Yeah. There would be no checks or checkbacks.
Okay.
Mhm. Yeah.
Any further questions for the witness? Thank you for your testimony.
You're welcome. Thank you.
Further witnesses in support of Senate Bill 1777.
Thank you, Chair and Committee. Kurt Wickmer with the Missouri Catholic Conference. We'd like to go on record in support.
Of all provisions?
Particularly for the provisions regarding SNAP benefits, shackling of mothers and juvenile offenders, as well as the good time behavior credit. in prison.
Got it. Any questions for the witness? Seeing none, thank you for your testimony. Further witnesses in support?
Mr. Chairman, members of the committee, Chase Campbell, just want to go on record in support for National Association of Social Workers, Feeding Missouri, and then Missouri Network Against Child Abuse.
Any questions for the witness? Seeing none, thank you for your testimony. Further witnesses in support? Seeing none, any witnesses in opposition? Seeing none, any witnesses for informational purposes only? Seeing none, I'll conclude the hearing on House Bill 1777 et al. Next up, House Committee Substitute for House Bills 2576 and 1433. Representative Casteel, whenever you're ready.
Thank you, Chairman, members of the committee.
My name is Representative David Casteel, 97th District. Today we're presenting House Bills 2576 and 1433 relating to trafficking of fentanyl. It does two things. It just modifies the statute to reduce the quantity eligible for trafficking to just above the lethal limit on fentanyl. And it also carves out carfentanil, which shouldn't be on the streets in any form whatsoever, as it is a large animal tranquilizer and should not be outside of veterinary clinics or hospitals. With that, I'll take any questions.
Any questions for the representative? Seeing none, thank you for your testimony. Witnesses in support. Witnesses in support. House Bill 2576. Seeing none, any witnesses in opposition? Seeing none, any witnesses for informational purposes only? Seeing none, that'll conclude the hearing on House Bill 2576. No further business coming before the committee. I would now make a motion that we adjourn. Do I have a second? It's been moved and seconded. We are adjourned.